Hello everyone, in this video we will try to solve previous year question paper of Delhi Judicial Service Examination that was held in 2010. Now I have already solved two previous year question paper earlier and you can find that also in my channel, and this is the third video that we are going to um, make together and try to solve the previous year question paper together. I am aware about the concept that there are many people who can't, there are many students who can't afford the previous year question paper books. Apart from that, they are unable to find that online too. So for those, this is the video especially I am making, and I was trying to solve this previous year question paper for my own to gain the knowledge, to expand my knowledge. I thought, why should not we both try to solve the previous year question paper together? Now in this paper, what I will do, I will choose the right option only. I will not repeat the whole options, all options. So if you want to read all options, you can just pause the video and start recording, start reading the other options. So just for saving my energy, I will choose the right option only, and I will say the right option only. Okay, I hope you will not mind. Today, no, today what I thought, what I was thinking, like I will try to solve at least four previous year question paper today. One previous year question paper will take me almost 1.5 hours. So if I will calculate, then um, 6 hours. It will take 6 hours to solve four previous year question paper. Apart from that, I also have to do the explanation, give the explanation of section 63 that I'm doing. Apart from that, whatever portion you are thinking that it's not gonna give you the benefit or advantage, you can skip that portion and try to save your time, as many time as possible. Okay, leave it. So I start with question number one. Which of the following is not an essential condition for the applicability of the rule of res sub judice? Let me check whether I am audible or not. Hello, yeah, it's working. So the first question of which of the following Which of the following is not an essential condition for the applicability of the rule of res sub judice? The right answer is the subject matter and cause of action should be same in both the suits. The subject matter and the cause of action should be same in both the suits. Wait, we have to read these options also. The matter in issue in the subsequent suit must be directly and substantially in issue. यहाँ पे है नॉट एन एसेंशियल कंडीशन. इन इशू इन द प्रीवियस सूट ये चाहिए होता है. बोथ द सूट्स मस्ट बी बिटवीन द सेम पार्टीज और देयर रिप्रेजेंटेटिव्स, ये भी होना चाहिए होता है. सच पार्टीज मस्ट बी लिटिगेटिंग अंडर द सेम टाइटल इन बोथ द सूट्स, ये भी होता है. द सब्जेक्ट मैटर एंड द कॉज ऑफ एक्शन शुड बी द सेम इन बोथ द सूट्स. सब्जेक्ट मैटर और कॉज ऑफ एक्शन समवेयर related होना चाहिए, है ना. So here the right option is option 4. Question number second. A alleging that he is the adopted son of X. A alleging that he is the adopted son of X sues B to recover certain property granted to him by X. A alleges that he is the adopted son of X, sues B to recover a certain property granted to him by X under a deed and forming part of X's estate. The court finds that A is not the adopted son of X, but he is entitled to the property under the deed and a decree is passed for A The finding that A is not the adopted son of X will not operate as res judicata in a subsequent suit between A and B, in which the question of adoption is again put in issue. Second, will operate as res judicata in a subsequent suit between A and B, depends on court's discretion. Fourth, none of the right option is second, will operate as res judicata in a subsequent suit between A and B. Question number 3. In which of the following cases the doctrine of constructive res judicata is not applicable? A sues B on a contract and obtain a decree. A sues B on a contract and obtain a decree. B afterwards sues for rescission of contract on the ground that it did not fully represent the agreement between the parties. Second, A sues B for possession of certain property, alleging that it has come to his share on partition of joint family property. B B's contention that the partition has not taken place is upheld and the suit is dismissed. A subsequent suit was filed by A against B for partition of joint family. Its right option is third only. Oh, sorry, second. Question number fourth. Mark the incorrect statements. Okay, these are those questions whose option I can't ignore. These are not direct questions, so I have to read all options. Apart from that, I know the answer because I already do the analysis and have the answers of these questions. So mark the incorrect statement. The court must be competent to try the suit at the time. The court must be competent to try the suit at the time of filing of the suit. Yes, it's true. Subsequent change in value does not affect the jurisdiction. It can. Subsequent change. Okay, it is the plaintiff's valuation in the plane that determine the jurisdiction of the court. True, and not the amount of which ultimately the decree may be passed by the court. It is true. If the pecuniary jurisdiction of the court is 10,000 and the plaintiff file a suit for account and finally the court finds on taking the account that 15,000 are due, the court is not deprived of its jurisdiction to pass a decree for that amount. Yeah, it's true. If the plaintiff undervalues or overvalues the claim for the purpose of choosing the forum, it is not the duty of the court to return it to file in the proper court. This statement is obviously wrong, as we can directly see. Question number 5. X is living in Pune and Y his brother in Mumbai. X is living in Pune and Y कहाँ रह रहा है? मुंबई में. X wants to file a suit for partition of their joint property situated in Delhi and Bangalore. ये रह रहे हैं पुणे और मुंबई में और प्रॉपर्टी इनकी है दिल्ली बेंगलोर में. अब कहाँ इसकी जुरिडिक्शन बन रही है? दैट्स एन इंटरेस्टिंग क्वेश्चन. लेट्स सी. The suit may be instituted in Delhi only. Why Delhi only? Why not Bangalore? ये तो नहीं होगा. The suit may be instituted in Bangalore only. ये भी नहीं. Why Bangalore only? Why not in Delhi? The suit may be instituted either in Delhi or Bangalore. None of the above. The fifth option, the fifth right option is third. The suit may be instituted either in Delhi or Bangalore. Question number 6. Mark the incorrect option. Mark the incorrect statement. A suit for accounts of dissolved partnership may be instituted either where the contract of partnership was entered into or where the business of partnership was carried on. A suit for dissolution of partnership carried on in a foreign country is maintainable in India if parties are resident there. The proper forum in the case of an ordinary agent is the place where the contract of agency was made or the place where accounts are to be rendered and payment is made by the agent. The right option is second. The suit for dissolution of partnership carried on in a foreign country is maintainable in India if the parties are resident there. ये गलत है. Question number 7. When an objection as a non-joinder or misjoinder of parties is upheld by the court may deal with the matter in controversy as regard the rights and interests of the party actually before it. The court should dismiss the suit. The court may allow the amendment of the plaintiff by striking out the names of such persons as have been improperly joined as plaintiffs or defendants. So the first is sahi, third is sahi. So the right option gonna be option 4. The court may deal with the matter in controversy as regard the rights and interests of the parties actually before it. The court may allow the amendment of the plaintiff by striking out the names of such persons as have been improperly joined as plaintiffs or defendants. Okay, right option is 4. Question number 8. Mark the incorrect statement. Why this is giving incorrect. It will give wrong impact to our mind. Just let me know. Give us the question that have a correct statement. Mark the incorrect statement in context of representative suit. So the options that we have: if the person suing or defending does not proceed with due diligence, the court can substitute in his place any person having the same interest in the suit. Can you give me a 5 second? Let me know what is due diligence. What is due diligence? Due diligence is the comprehensive investigation and careful evaluation of a business. Reasonable steps taken by a person to avoid committing a tort or offense. Okay, if a person suing or defending does not proceed with due diligence, the court can substitute in his place any person having the same interest in the suit. The suit can be withdrawn, compromised, or abandoned by the plaintiff after notice to all persons interested. Any decree passed in such a suit is binding on all persons interested. Res judicata is not applicable to such a suit. Incorrect option is 4. See the ninth question. In which of the following cases amendment of pleadings could be allowed to introduce a new or inconsistent cause of action, to take away a right of the defendant which has accrued to him by lapse of time, for granting relief on the basis of different approaches to the same facts, amendment taking note of subsequent events. The right option gonna be option 4, that is third and fourth. So this is the following case amendment of pleading could be allowed. This is allowed for granting relief on the basis of different approaches to the same facts, and amendment taking note of subsequent events. Question number 10. Where the serving officer deliver or tender a copy of the summons to the defendant personally or to his agent, he must require such a person to sign an acknowledgement of service to be endorsed on the original summons. Then the copy of the summons will be delivered to the defendant. The original summons with the defendant's signature thereon will be returned to the court. Both first and second, the original summons with defendant's signature thereon will be returned to the plaintiff. The original summons with the defendant's signature thereon will be returned there to. Right option is option third, that is both 1 and 2. So this is right. The copy of summons will be delivered to the defendant. The original summons with the defendant's signature thereon will be returned to the court. Question number 11. No one can be ordered to attend in person. Don't think that I am trying to teach you all. Not at all. Never. We both are learning together. I was learning alone. I was trying to learning all alone. So I thought if I am solving and you can get the advantage from that, so why not? So that's the only sole purpose of this. So we both at least can learn together. No one can be ordered to attend in person to give attendance in a civil suit unless he. No one can be ordered to attend in person to give attendance in a civil suit unless he resides outside. Okay. This is very interesting question. No one can be ordered to attend in person to give attendance in a civil suit unless he resides outside the local limits of the court's ordinary original jurisdiction, but at a place less than 100 kilometer distance from courthouse. Resides outside the local limits of the court's ordinary original jurisdiction. Resides within the local limits of the court's ordinary original jurisdiction. Reside outside the local limits of the court's ordinary original jurisdiction, but at a place less than 100 kilometer from the courthouse. Can you give me a can you give me a couple of minutes? You can skip this portion. I it is very kind of relevant question that I was looking for. Okay, got it. See, the right option for question number 11 is resides outside the local limits of court's ordinary original jurisdiction, but at a place less than 100 kilometer distance from the courthouse. Means this question is asking कि किसको बुला सकते हैं और किसको नहीं बुला सकते हैं, किसका घर कहाँ पर हो तो नहीं बुला सकते हैं। तो ये कोर्ट है, इसकी जुरिस्डिक्शन जो है, इस जुरिस्डिक्शन के में तो के आसपास के लोग तो इस जुरिस्डिक्शन के लोग तो बुला ही सकते हैं। इसके अलावा जो है, इसके अलावा 100 किलोमीटर अप टू 100 किलोमीटर के अराउंड जो है वो कोर्ट जो है समन करके उसको बुला सकता है, उससे आगे का नहीं। दिस इज व्हाट इट मैंट। एंड क्वेश्चन नंबर 12, mark the incorrect proposition. Set off is a statutory defense to a plaintiff's action, whereas a counterclaim is a cross action. Set off and counterclaim arises out of the same transaction. Set off should not be barred on the date of the suit, while counterclaim should not be barred on the date of filing of written statement. Claim for set off cannot exceed plaintiff's claim, whereas counterclaim can exceed the plaintiff's claim. Both set-off and counterclaim cannot exceed the pecuniary jurisdiction of the court. The right option is second, that is second only. Means set-off and counterclaim arises out of the same transaction. Question number 13. Mark the correct statement. The question which are put only to test the creditability of a person will not be allowed as interrogatories, although they may be asked in cross examination. Interrogatories can be administered only to a party to a suit and not to a witness, whereas cross examination can be of any part, any person, parties and witness alike. A party filing affidavit in reply to interrogatories can never cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. As it is a conclusive proof. All of the above. So the right option is for that is all of the above. Wait, let me read the all option one more time. The question which are put only to test the credibility of a person, credibility of a person will not be allowed as interrogatories, although they may be asked in cross examination. Interrogatories can be administered only to a party to a suit and not to a witness, whereas cross-examination can be of any person, parties, and witness alike. Interrogatories can be administered only to a party to a suit. Okay. A party filing affidavit in reply to interrogatories can neither cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. Its right option is option 4, that is all of the above. Question number 14. A suit may be dismissed under Order 9 of Code of Civil Procedure 1908, where the summons is not served upon the defendant in consequence of the plaintiff's failure to pay cost for serving of summons, where neither the plaintiff nor the defendant appears, where plaintiff after summons return unserved, where plaintiff after summons return unserved fails for 7 days to apply for fresh summons, where on the date fixed for hearing in a suit only defendant appears and he does not admit the plaintiff's claim. 14th का right option है, that is 4, that is all of the above. चारों ही सही है. Neither the plaintiff nor the defendants appear. Where plaintiff after summons returns unserved, fails for 7 days to apply for fresh summons. Where the date fixed for hearing in a suit only, defendant appears and he does not admit the plaintiff's claim. Question 15. In a suit for recovery instituted by A against B, despite the summons of suit having been duly served upon B, he did not appear on the date fixed in the summons on 1st of March 1993. The court consequently on 1st March 1993 passed an ex parte order against B and listed the case for 3rd April 1993 for ex parte evidence of A. B can participate in further proceeding of the case. B can seek setting aside of ex parte order if he is able to show good cause for his non-appearance. Third, both first and second are correct. 16. Mark the incorrect statement in relation to Order 23. In relation to Order 23 of Code of Civil Procedure 1908. At any time after the institution of a suit, the plaintiff may withdraw his suit or abandon part of his claim. If a plaintiff withdraws from a suit without the court's permission, he is precluded from instituting a fresh suit against the same defendant in respect of same subject matter. If the court is satisfied that a suit must fail by reason of some formal defect or there are other sufficient grounds, it may allow the withdrawal from suit. The right option of question number 16. Question number 16 is option 4, that is, when there are several plaintiffs, the court can allow one of them to withdraw even if other co-plaintiff does not consent to such withdrawal. Question number 17. Compensatory costs can be imposed if the claim or defense is false or vexatious and subsequently disallowed or withdrawn. If objection to the false or vexatious claim or defense has been taken by the party at the earliest opportunity. Both first and second correct. Both first and second is are wrong. The right option is option third, that both first and second are correct. Let me see who came. Sorry for the inconvenience. It was my father's call, so I could not skip that. I hope I am audible, still audible. Question number 18. Where any parties die, where any party dies, where any party dies. After conclusion and before pronouncing of judgment, the suit shall not abate. Question number 19. A relief of injunction may be refused on the ground of a relief of injunction may be refused on the ground of laches or acquiescence. The applicant has not come with clean hands. Where monetary compensation is adequate relief, all of the above. So right option is 4, that is all of the above. Question number 20. Where it appears to the court that elements of an acceptable where it appears to the court that elements of an acceptable settlement exist, the court may refer it to arbitration, conciliation, mediation, as well as judicial settlement, including that through lok adalat. So the both option are correct, first and second. Question number 21. Mark the correct statement. First, evidence excluded by the Evidence Act is inadmissible even if it seems essential for ascertainment of truth. Option second, parties cannot contract themselves out of the provisions of the act. Third, a court cannot, on the ground of public policy, exclude evidence relevant under this act. Option 4, that is all of the above. Here the right option is option 4, that is all of the above. Let me read second and third option one more time. Parties cannot contract themselves out of the provision of the act. A court cannot, on the ground of public policy, exclude evidence relevance under this act. So all of the above. Question number 22. A is accused of a child's murder. The following facts are construed in the case. First, an hour before the murder, A went to the place of murder with the child. Second, A alone returned home. Third, collar of A's shirt found to be blood stained. The evidence which takes into account the above mentioned fact is called circumstantial evidence. Circumstantial evidence. Question number 23. Mark the incorrect statement. The term relevancy and admissibility are coextensive or interchangeable terms. Question number 24. The question is whether A owes B rupees 10,000. The fact that A asked C to lend him money and D said to C in A's presence and hearing, I advise you not to trust A for he owes B rupees 10,000, and that A went away without making any answer is a relevant fact. 24 na? Yeah, it's a relevant fact. Question number 25. A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector packet of currency notes. He told the inspector that B had sent the money as a consideration for hushing up the case against him. The offer of money and the accompanying statement made by A were relevant against A only, B only, both A and B. Question number 26. Admissions by agents are always admissible in civil proceedings. Admissible in civil proceedings only if the agent has the authority to make admissions. So the right option is 4. That is both. Wait. Um, Admissible in civil proceeding only if the agent has authority to make admission, not admissible in criminal proceeding. So the right option is 4th. Question number 26. Question number 27. Question number 27. Telling his wife that P's wife had called him to receive payment due to him, K leaves his house. After 2 days, his dismembered body is found in a truck. In P's trial for murder of K, the statement made by K to his wife is inadmissible, partly admissible, inadmissible as it does not directly relate to K's death, admissible as it relates to circumstance of transaction which resulted in K's death. So the right option is option 4. Question number 28. If X is charged with Y's murder, which of the following will be hearsay evidence? If X is charged with Y's murder, which of the following will be hearsay evidence? Z in his evidence states that I saw X stabbing Y with a knife. Evidence of A that Z told me that he had been X stabbing Y. सेकंड होगा इसका आई गेस 20 या इससे सेकंड ये तो डायरेक्ट एविडेंस हो गया ना और द सेकंड वन इज हियर्स एविडेंस क्वेश्चन नंबर 29 if on the carbon copies of a letter written on a typewriter signature have been put on the first letter then other copies will be secondary evidence. Question number 30. If no attesting witness can be found, it must be proved that if no attesting witness can be found, if no attesting witness can be found, it must be proved that attestation of one attesting witness at least is in his handwriting, signature of person executing the document is in handwriting of that person, both first and second. The right option is both first and second. Question number 31. X sues Y for money due on a bond. The execution of the bond is admitted, but Y says that it was obtained by fraud, which X denies. The burden of proof is on Y. Question number 32. In which of the following cases the court may presume under section 114, under section 114 that a man in possession of stolen goods after the theft is either the thief or has received the goods knowing them to be stolen, that judicial and official act have been regularly performed, that that evidence which could be and is not produced would if produced be unfavorable to the person withholding it. For example, the police withholding a piece of evidence. The right option is option 4, that is all of the above. Question number 33. Which of the following is an exemption to the doctrine of estoppel? Which of the following is an exemption to the doctrine of estoppel? The option that we have, where a minor represent fraudulently or otherwise that he is of age and thereby include or thereby induce another to enter into a contract with him. Second, when true facts are known to both the parties, when the representation is against the statute, or all of the above. Right option is option for question number 33 is 4, that is all of the above. Question number 33 is all of the above. See the question number 34. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. Let me read it one more time. A intentionally and falsely lead B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterward becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. 34. A must not be allowed to prove his want of title. Question number 35. A local development authority announced a housing scheme and accepted applications under it, subsequently finding that the scheme was in violation of the master plan, cancelled it. The right option is it is free to do so without any shackles of promissory estoppel, as there cannot be any estoppel against the government in exercise of its sovereign legislative and executive functions. The right option is option third. Question number 36. Which is the most appropriate definition in relation to a hostile witness? A hostile witness is one who, from the manner in which he gives the evidence, shows that he is not desirous to telling the truth to the court. Question number 37. This question paper is kind of long compared to the previous year question paper, because in that I thought there are almost 20 pages, but in this there are almost 29 pages, almost 30 pages. Shall we continue? Question number 36 we have already done. See the question number 37. Confession of a co-accused not required to be on oath and cannot be tested by cross-examination. The right option for question number 37 is 4, that is only second and third. Now, what second and third says, the only limited use which can be made of a confession of a co-accused is by way of furnishing an additional reason for believing such other evidences as exist. It is a very weak type of evidence and is much weaker even than the evidence of an approver. The right option is option 4. Question number 38. A disputed handwriting can be proved by calling an expert, by examining a person acquainted with the handwriting of the writer of the question document, by comparison of the two admitted and disputed. The option is 4, that is all of the above. Question number 39. Cross examination of a witness must relate to relevant facts but need not be confined to what the witness testified in examination in chief, but need not to be confined to what a witness testify in examination in chief. The right option is second. Question number 40. After re-examination of a witness, the adverse party has right to further cross-examine the witness only when a new is introduced in the re-examination. Option third is the right option. After re-examination of a witness, the adverse party has right to further cross-examine the witness only when a new is introduced in the re-examination. Question number 41. Which of the following is not an essential search produce under section 100 of the Code of Criminal Procedure 1973? The right option is signature of the accused on the search list. Now, which of the following is not an essential search procedure and signature of the accused on the search list? Joining of two independent and respectable inhabitants of the locality in the search as witness, signing of search memo by the witness to search, attendance of occupant of the place during the search, or attendance of occupant of the place during the search, signature of the accused one. Okay, this is not mandatory. This is not it is not in need what we say. Question number 42. In relation to first information report, which of the following statement is not correct? The right option is it cannot be used as a previous statement for any purpose. Right option is third. It cannot be used. It is not substantive evidence. It merely marks the beginning of the investigation. The informant need not be an eyewitness. It cannot be used as a previous statement for any purpose. Right option is third only. See the next question. Question number 43. What it says: if two or more courts not subordinate to the same high court have taken cognizance of same offence, and a question arises as to which of them how to inquire, the question is to be decided by the question is to be decided by the court in which proceeding first commenced, the High Court within the local limits of both of whose appellate criminal jurisdiction the proceeding first commenced, the Supreme Court. Question number 44. 44. Question number 43. Wait, this is wrong. Right option is the High Court within the local limits of whose appellate criminal jurisdiction the proceeding first commenced. See question number 44. Under section 198 of the Code of Criminal Procedure 1973, no court can take cognizance of an offence against marriage. Under section 198 of the Code of Criminal Procedure 1973, no court can take cognizance of an offence against marriage punishable under Chapter 20 IPC unless a complaint is made by a police, ठीक है, the police, the wife or husband, some person who is aggrieved by the offence, all of the above. The right option for question number 44 is third, some person who is aggrieved by the offence. क्यों करता हूँ मैं ऐसी गलतियाँ, क्यों, why? Okay, अंडर सेक्शन 198 है, some person who is aggrieved by the offence. Question number 45. If it appears to the magistrate that the offence complained of its tribal exclusively by the sessions court, he under section 202 of the Code of Criminal Procedure 1973, postponing the issue of process against the accused, third, shall call upon the complainant to produce all his witnesses and examine them on oath. Let me read this question one more time because I didn't get this. Question number 45 says, if it appears to the magistrate that the offence complained of is tribal exclusively by the session court, he under section 202 of the Code of Criminal Procedure 1973, postponing the issue of process against the accused, shall call upon the complainant to produce all his witnesses and examine them on oath. See question number 46. In which of the following cases an error or omission is charged is not material? In which of the following cases an error or omission in charge is not material? A is charged with cheating B and the manner in which he cheated B is not set out in the charge or is set out incorrectly. A defends himself, calls witnesses and gives his own account of the transaction. First is the right option. A is charged with cheating B and the manner in which he cheated B is not set out in the charge or is set out incorrectly. He defends himself, calls witnesses and gives his own account of transaction. Let me clarify you. If you want to read the other option, you can just pause the video and start reading the other options. Question number 47. Whenever a charge is altered or added to by the court after the trial has commenced, the prosecution has a right to recall or resummon any witness who has already been examined. Question number 48. Is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. He is only charged with theft, but it appears that he committed the offense of criminal breach of trust. He may be he may be convicted of criminal breach of trust. He may be convicted of criminal breach of trust. Question number 49. If the complainant is absent on the day fixed for the hearing of the warrant case, the magistrate may discharge the accused if the proceedings have been instituted upon complaint, the offence is not cognizable or compoundable, The charge has not been framed. Fourth, all of the above. Question number 50. Under section 313 of the Code of Criminal Procedure 1973, no oath shall be administered to the accused when he is examined. No oath shall be administered to the accused when he is examined. The accused shall render himself liable to punishment for refusing to answer questions or by giving false answers to them. The answer given by the accused cannot be taken into consideration and put in evidence for or against him in any other inquiry, trial for any other offence. Every error or omission is complying with section 313 necessarily vitiates the trial. The right option for question number 50. The right option for question number 50 is option first, that no oath shall be administered to the accused when he is examined. Question number 51. Question number 51. What question number 51 says? Mark the incorrect statement. Section 319 of the Code of the Section 319 of Code of Criminal Procedure 1973 could not be evoked where the trial has not begun and no evidence has been recorded. Section 319 of the Code of Criminal Procedure 1973 could not be evoked where the trial has not begun and no evidence has been recorded. Section 319 of the Code of Criminal Procedure 1973 could not be invoked where the trial has not begun and no evidence has been recorded. The power to proceed against a person not named as an accused is to be exercised sparingly and for compelling reason. The provision of Section 319 of the Code of Criminal Procedure 1973 applies to all the courts including Session Code. None of the above. The right option is none of the above, means every statement is correct. Question number 52. When the person who would otherwise be competent to compound an offence under section 320 of the Code of Criminal Procedure 1973 is dead, then legal representative of such person can compound the offence with the consent of the court. Question number 53. Whenever a magistrate is of opinion after hearing the evidence for prosecution and the accused is guilty and that he ought to receive a severe punishment, then such magistrate is empowered to inflict. The magistrate may forward the case to session judge, chief judicial magistrate, district magistrate, concerned police station. ये तो कतई नहीं है, ये तो है ही नहीं. और 53 का है सेकंड, चीफ जुडिशियल मैजिस्ट्रेट. क्वेश्चन नंबर 54. When can a trial court release an accused on bail under section 389 subsection 3 of Code of Criminal Procedure 1973 after conviction where accused is on bail and imprisonment is not exceeding 3 years? The right option is first. See question number 55. Assertion A. Bail, not jail, is the general rule in bailable offence in India. Reason: personal liberty is the most cherished right of a human being. Bail is the general rule. Yeah, both are correct. Both A and R are individually true, and R is the correct explanation of A. तो इसका यही होगा ना, फर्स्ट ऑप्शन फर्स्ट. Question number 56. Match list 1 and list 2 and select the correct answer using the codes given below the list. Summary trial, bail, summary trial, bail, search warrant, judgment petty, release from prison, bail, release from prison. Summary trial, speedy disposal of case. judgment, petty, conviction or acquittal. Search warrant, a written authority to पुलिस ऑफिसर. तो इसका क्या बना? ए का 4, बी का फर्स्ट, सी का सेकंड, डी का थर्ड. अब ऐसा कोई आंसर हमें मिलेगा तो वही होगा. ए का 4, बी का फर्स्ट, सी का 2. ए का 4, बी का फर्स्ट, सी का 2. ए का 4, ए का 4, बी का फर्स्ट, सी का 2, डी का 3. दिस इज द राइट ऑप्शन. डी का 3 है ना, डी का 3. 56 का ऑप्शन 4 इज राइट. वेट, या ऑप्शन 4. सी नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 57. The liability of a surety under the surety bond, the liability of a surety under the surety bond is mutually exclusive of the liability of the accused under his personal bond, contingent on the liability of the accused under his personal bond, limited to the amount of the surety bond, both first and third. The right option is first, both first and third. Means the liability of a surety under the surety bond is mutually exclusive of the liability of the accused under his personal bond, limited to the amount of the surety bond. Okay, right option is first and third both, means option 4. Question number 58. Question number 58. In computing the period of limitation, the time during which in computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution in any court against the offender shall be excluded. The period during which an offender is absent from India shall be excluded. The period during which an offender is absconding, concealing himself is excluded. The right option is option 4, that is all of the above. Question number 59. In a joint trial where several accused persons are being tried, one accused examines himself as a witness. Now, only that co-accused has a right to cross-examine the accused, examining himself as a witness against whom such an accused has disposed something. The right option is option 3rd. Question number 60. Period of limitation shall commence. Period of limitation shall commence from the date of the offence generally. From the date of the offence generally. From the date of knowledge of commence of the offence if not known earlier, from the date of establishment of the identity of the accused if not known at the time of the commission of the offence, all of the above. So the right option is 4, that is all of the above. And with this we have done almost 60 question, exactly 60 question, and we will try to do the remaining question in our next part. I have to take a 5 to 15 minutes break, and then we will continue the rest of this question in our next video. Till then, have a good time. See you. Keep practicing. Bye bye.